Hi, everyone. Welcome to Cannabis Updates, brought to you by the law firm of Tonkin Torp. I'm your regular host, Danica Foster. When we do these segments, one of the attorneys here at Tonkin and co-chair of the Cannabis Industry Practice Group. Today's date is February 16th, 2022, and we intend for the information provided today to be accurate and up to date as of the date of this recording. But as we all know, cannabis industry laws and policies and trends change rapidly. So it's important to consult your legal counsel, stay up to date, and stay tuned for future segments that we may do on cannabis law updates. Today, I'm lucky enough to be joined by Kimberlee Stafford. Kim is a colleague here at Tonkin, a partner, and also a member of the Cannabis Industry Practice Group. She represents a lot of cannabis businesses, and she really would be your go-to for cannabis real estate needs. So today, I think we're going to talk a little bit about some of the issues and special risks that landlords may have in leasing to cannabis businesses. Some of the things that they may need to think about if for landlords of cannabis. Today, we're going to talk a little bit about some of the special issues that owners of real estate may want to think about when they're leasing to cannabis businesses, some special issues or risks that may increase their potential liability. So Kim, what are some of those risks? What makes a tenant default under a cannabis lease risky for a cannabis or a landlord?
Yeah, so one of the biggest issues for landlords is what they are legally allowed to do if their tenant defaults. So with non-cannabis leases, most commercial leases allow the landlord to re-enter the property on a tenant default, remove the tenant's personal property, and then re-let the premises to someone else. The issue with cannabis tenants is that the landlord can't handle the cannabis product without having a license. So really, self-help and lockout rights aren't available for those landowners. Instead, they really need to go through a court process, whether or not that's getting a judgment or going through a commercial FED process to evict the tenant. They need to use the courts before they'll be allowed to, in the case of getting a judgment against the tenant, and they may be able to get a license to dispose of the cannabis, or otherwise may be able to get the help of OLCC. But it's really important that they don't do that without having a license first. Yeah, so what this really underlies is the importance of vetting tenants if you're going to lease to a cannabis business, because it is so difficult to be able to re-let to someone new if your initial tenant defaults on the lease.
Yeah, most definitely. I mean, you don't want to be stuck in that situation. So I think that sounds like some great advice of just doing some extra vetting of cannabis businesses. Are there other things a landlord can't do besides, being able to handle it or take other sort of self-help remedies that might be otherwise available?
Yeah, another related issue is, that because cannabis licensees are required to have security systems, landlords aren't allowed to have any sort of control or access to that security system. So they have to be careful not to mess with the security system, and they can't be in areas where the cannabis product is without having the licensee there with them. And so those are other things that landlords need to be careful about.
We've heard a lot in the news lately about law enforcement seizing illegal cannabis grows that were purportedly hemp, but really was just not actually hemp. It was actually marijuana being grown. Do landlords or landowners have any liability if their tenants are not operating lawfully?
Well, the short answer is yes. More and more, we've been hearing that it's become such a large issue that law enforcement is looking at ways to prosecute landowners, potentially for criminal conspiracy, if the landowner knew or should have known that their tenants were growing cannabis illegally. So the law enforcement is looking at things like the tenant improvements, or, in the case of hemp, if it's a grow that's indoors, when hemp is really an outdoor crop, that a landowner should have known that this indoor grow was not actually hemp. So, it's becoming a large issue that law enforcement is focusing on. it could potentially expose someone to a lot of liability, because often these grows are associated with other crimes that could expose a landowner to liability, such as human trafficking, environmental contamination, or misappropriation of water rights. So, these are things that a landowner or landlord does not want to be associated with. And once again, this just highlights the importance of, as a landlord, vetting your tenants ahead of time. You may want to actually even get copies of the licenses or hemp registrations so that you know whether or not your tenants are actually complying with those licenses or registrations. And you trying to remain ignorant of what your tenant is doing is not going to protect you.
Well, thanks so much, Kim. This is just great information for both landlords and cannabis businesses to know, since there's so many nuances to this, and there's a very different type of relationship in landlord and tenant situations when cannabis is involved. So on behalf of Tonkin Torp, we thank you all for watching and listening. And you'll find both mine and Kim's email addresses at the beginning of this segment if you have further questions or have real estate related needs. Stay tuned for our next segment, which is in the works, regarding some really interesting and dynamic legal developments coming to the cannabis world that is in the pending legislative session. This concludes this session, which was recorded on February 16th, 2022.